Hello and welcome to the Smart Divorce Podcast. I'm delighted to be joined this afternoon by Sarah Birdsey of Nicholls Solicitors in Timperley, which is apparently a village just south of Manchester. Um, hi Sarah, how are you doing?
Hi, Tamsin. I'm fine, thank you. You okay?
Yeah, I'm good, thank you. Thank you for joining us this afternoon. I will let you introduce yourself in a little bit more detail because can you tell us a bit about what you do and who you work?
Yes, so I'm managing director at Nicholls Solicitors, and I'm a family lawyer here. I'm a specialist accredited member of the Resolution as well, which is a group of family lawyers which are dedicated to resolving matters amicably. And yeah, we work here in Timperley Village. There's a small team of us. We're a high street practice, so we deal with wills and probate, conveyancing, litigation, and family law.
Fantastic. But your area is family law, is divorce and separation, isn't it?
Yes.
Fantastic. And so today we're going to talk a little bit about separation in all its numerous guises. So I thought we would start off today by talking through separation agreements. So can you explain to start with what one of those is and why you might want one?
Yes, so a separation agreement, I suppose there's two forms of separation agreement. There's those that you would use for separating unmarried couples, and those that you would use when married couples are separating. And they're useful in that they can set out, obviously the financial arrangements and other arrangements, following a separation. With unmarried couples, then that might be, the only agreement that there is. And it's basically, it would be a contractual agreement that sets out, if there's a joint property, for example, if that's going to be sold, what the terms are of that sale, who's going to pay the mortgage pending the sale, who's going to live in the property, how they might divide the contents. And say it's a contractual agreement, so it would be binding on the parties, and they'd have like a civil procedure route if they needed to enforce it. But they're also useful where there's married couples that are separated and they maybe need to resolve the finances, but need to do it sooner rather than later. With the divorce financial order, which is a consent order, that can't be approved by the court until much further down the line. So when you've got your conditional divorce order, and sometimes, especially at the moment, with the mortgage rates being as they are, people are keen to secure mortgages, so they might want to deal with the transfer of the property or selling the property, at much quicker rate, really. And so they're used then to sort of set out what the terms are that are agreed, and then the idea is that it's then approved at a later date when they've issued the divorce proceedings, and it can be approved through the courts.
Okay. So are they generally used for, so let's take the example of a married couple to begin with. With a married couple, are they generally used to agree all of the different finances that you will look at separating in the actual divorce, or does it just concentrate usually on one element?
It depends on the situation, really. I suppose, every situation is slightly different. Usually, I suppose ideally, you would deal with everything in the separation agreement. But it depends, it might be if there's some urgency, that you need to deal with the property, it may need to address that. But pensions, for example, resolving that issue can take some time because sometimes you're waiting for pension companies to provide information. You might need to get advice from, pensions experts on how best to divide those. So it might be that you need to deal with it in a bit more piecemeal way and have the separation agreement addressing some of the aspects, and then, obviously finalize it in due course, along with the divorce.
Okay. Are there any downsides to separating things in that sort of piecemeal way?
Yeah, I mean, there's still a risk. Separation agreements in that context aren't, 100% binding. What the courts would say is that as long as they're done properly, there's full disclosure, so you both know exactly what you're entering into, you know what all the assets are, and you both had legal advice on the agreement, then generally it should be upheld when the divorce order's done. But the court does still have the power to make a different order. So if there's an element of it that doesn't seem to be fair, or if there's a dramatic change in circumstances between doing that agreement and the financial order being put before the court, then there is a risk that the court could say, well, actually, this isn't an order that seems right to me. I think it should be adjusted in some way. So there is that element of uncertainty. But generally the courts say, as long as it's fair and it's been done properly, we will uphold it. But as I say, there is still that risk, really.
Yeah, I guess the risk is you each go off with your share of the house and go and buy a house, and then the court decides that one of you should have more of the equity or whatever, and then it becomes a bit trickier to resolve.
Yeah, exactly. Is that, and in that situation, you can end up then having to sell your house as a worst case scenario. If you needed to adjust the shares or anything. And also, if you were going to do it in a piecemeal way, and you sort of divided the house money, for example, and then you had your advice about your pensions, it might be that you would have divided the house differently. You might want to try and offset that pension share, and deal with it that way. So it's not, I suppose it's not ideal really to deal with it, by a separation agreement. But the timings are such that with the financial order on the divorce, it's quite a few months before the court can approve that order. So there are times when, they can be useful.
So let's talk a bit about timescales, because I think that would be a useful thing to talk about. So at the moment,
yeah,
from the point where you think where you decide to file for divorce. So talk us through the timescales if you were going for the financial consent order from the beginning, and how things might be speeded up if you were looking at a separation agreement instead.
Yeah. So at the point where you issue the divorce, that's issued, and then there's a 20-week wait before you can apply for your conditional order. And when we've been applying for the conditional orders, they're generally being listed a month later. And it's not until you've got that conditional order that the court can approve your financial order. So it's a good few months, before the court can approve that. And then 6 weeks after that, you can apply for your absolutes. And it's when you get it's not called an absolute anymore, a final order.
We're still in that crossover world, aren't we, where we've got some that are absolutes and some that are final orders. And
yeah. When you got your final order or your decree absolutes, that's when your financial order is binding as well. So you're looking at, about 7 or 8 months even, before that financial order is going to be, sealed and approved and final. So if you had a separation agreement, that could say, for example, you could do that in the early stages, and that might record that the house is going to be sold and it's going to be split. And when the time is right, you're going to send a consent order to the court to say, dismiss all of the claims. We've already split the house. There's nothing else to do, sort of thing. And that's in full and final settlement. And so it's just a matter of the court then really just putting a seal of approval on the agreement you've already done.
Okay. And the separation agreement, that if that's put in place in the early days, is that something that has to be ratified by the court, or is that just something that's done between the two lawyers and therefore it could be done in a matter of weeks?
Yeah, it's just something that's done between the two solicitors. So it can be done relatively quickly, as long as you've got all the information there, and so as long as you both do get the legal advice on it. yeah, that can be sorted out relatively quickly, really.
Oh,
And I usually, if I can, attach to it a draft of the consent order that we would send to court down the line, so that again there's no disagreements further down the line when you do come to submit it. It's all there. There's, it's all clear for everybody. And yeah, I just feel like that gives it a bit of extra weight as well. But it depends on whether you've agreed, everything, and whether you can do that or not, really.
absolutely. And do separation agreements get used where people are not ready to divorce or not, or perhaps
Yeah.
even in some cases for religious reasons, for example, don't want to go down the divorce route but want to separate and have their finances separated?
Yeah. So that's another time that they can be used. So some people don't want to get divorced, like you say, religious reasons or otherwise. So it's a way of formalizing, that financial division of assets. And addressing, for example, who is going to pay, any bills or maybe pay any liabilities and things like that. So yeah, that can be done. It's just, I suppose, the risk is that if you separate now and you don't divorce for many years, the court can still look at that separation agreement, at that future point when you do divorce, and so it can get a bit complicated. If it's a long time in the future.
So for clarity, in England and Wales, because that's specifying that because that's the law under which you operate and we operate, so it may be different in Northern Ireland or in Scotland or other countries that you might be listening to this podcast in, because we do have the odd listener in the US.
Yeah,
so check out the law where you are. But in England and Wales, your financial severing isn't done just by filing for divorce, is it? It actually requires that financial consent order, the agreement that's everything done and dusted to financially separate you. So it's not a question that it regards just the assets that you have on the date of separation, is it? It's actually much more complex than that. Could you just give us a little bit of a, I know this is complicated and it's going to be, and it depends, but just broadly speaking, what's the situation if you separated a really long time ago, let's say 10 years ago? What is the situation if you were looking at assets for a couple who separated that length of time ago?
So if they separated that length of time ago, if they divided the assets at that point, there's a good argument there to say, well, that should be upheld, and anything since then, is post separation. It shouldn't be treated as a matrimonial asset. But the courts, so they still have that power. They still have to sort of sign it off at that divorce point. So they still have to be happy that what was agreed at the time was fair. And I suppose it's just, there's still that risk of, if there's been a huge change in circumstances, if one party is, I don't know, lost everything and is destitute, and the other party's made millions, a court might say, well, actually, maybe there should be some further adjustment. It really does depend on the circumstances, really.
It depends.
But it's surprising, actually. You mentioned about, you do need that financial order. There's it's quite common for people to get divorced and not do the finances at all, not deal with them, even leave property just in joint names and leave things in abeyance. But it's so difficult to sort out, 10, 15 years down the line. But it does happen, there are cases like that.
Yeah, absolutely. It's definitely best to deal with at the time. Okay, let's move on to cohabitation for a while. So cohabitation laws are completely different, aren't they, to marriage? So let's start off with the fallacy of common law husbands and wives.
Yes.
So that's not a thing, is it?
No, it's definitely not a thing. But you know, it's a common myth, really, and people still talk about common law, and it drives me insane when I come to renew things like car insurance, or and it's a box that you can tick, common law partner. It's like this doesn't exist.
Okay.
Yeah. So yeah, I mean there's lots of talk about reform, but at the moment there's no law that governs cohabiting couples. So you're just dealing with, you know, contractual law and land law principles really. So usually when cohabiting couples separate, there's a property that needs to be dealt with. So, you know, whether the property is being sold or one party wants to buy the other out, you know, that can obviously be incorporated into a separation agreement. And the agreement can go into, you know, quite a bit of detail. So it might say, well, you know, this party wants to buy the other out. They have a period of time to do that. If they don't do it in that time, especially with the mortgage rates being as they are, then the house is sold, and it can stipulate which estate agents it goes on the market with, which solicitors
Oh,
do the
wow.
conveyancing, you know, all of that detail, so that hopefully there's not any future disputes. You know, it's all sort of there in black and white. And it can set out, you know, who's going to pay the outgoings, who's going to pay any liabilities, how they're going to divide contents, and even, you know, who's going to look after pets, you know, provision for things like that. So they're really useful to do, and they're quite important in that context. You know, to have something that's formally written up so that everybody knows where they stand, really.
Absolutely. So in terms of just not spending ages and ages going into cohabitation, but just broadly speaking, if you got a property, because this quite often happens with couples when they've got divorced and then one of them might move in with another partner. So if you're living in a house that belongs to somebody else in their name, so whether it's someone you're romantically involved in or not, if you're living in a property that's in their name and you have fallen out and split up, you're essentially, it's still their property, isn't it? However much you might have contributed to it, however much you might have paid the bills or food while they paid the mortgage, that's still their property, isn't it?
Yeah, there are ways that you can claim a beneficial interest in it, but it's quite a high threshold. You'd have to show that there was some common intention that you would, you know, get a share in this property. And when that's not been written down in any sort of formal document, then it's really one word against another. And it's rare that people have those detailed conversations where they say, okay, yeah, you build an extension and you can have half of the house. But yeah, I mean, where there's an express common intention and there's a financial contribution to the actual house, in terms of, you know, a financial contribution to the mortgage, or improving the value in some way, like by, you know, paying for an extension. There are circumstances where you could make a claim, but generally speaking, if someone's just living in the property and contributing to bills and food, they wouldn't generally get, you know, any interest in that property.
Yeah, that's a massive warning, I think, for people who are moving into somebody else's property that's in their name with no civil partnership or marriage there and no cohabitation agreement, setting out what your plans are for how you're dealing with finances. That can be a big risk, and I think a lot of people don't understand that they don't have the same rights as married couples, and it's a long way off, you know, it's a long way off the same rights as married couples, isn't it?
Yeah, it's a huge difference. Yeah, there was a very, very famous case, I'm sure you know about, where, you know, someone had lived in this property, but it wasn't in their name. They'd lived in there for 25 years and just thought that they would, you know, get a share of it, and it just doesn't work that way. And also, you know, there's a difference in terms of pension rights. You know, when you're cohabiting, you get none of those other rights that you would do if you were married. So there is a really big difference, and there's a lot of you know, misunderstanding about it as well. which is a concern really.
No, absolutely. That's you're spot on there. I think it's just really important to get these things in writing, get them,
Yeah.
set out legally with solicitors or in the case of marriage with a court. So separation itself it is
Yes.
an incredibly complex area. So when you're at the beginning of your divorce journey, you will probably complete financial disclosure. And I know most people, whether you're going to court or not, will look at completing a Form E so that they can exchange their financial information with their soon to be ex-spouse. On that document, you have to document the date of separation. And this seems to be incredibly complicated to figure out what that date is. So could you give us some guidance as to what date should be used?
Yeah, so in some cases, I suppose it is straightforward. It's, there's something that happens, one party moves out, and doesn't move back in, and that's the end of the relationship. So in that scenario, it's straightforward. Obviously, I mean, particularly at the moment, we're seeing a lot of couples that separate and decide that they're going to divorce, but they have to stay in the family home because, finances don't allow them to move out. And so in that case, it can be more difficult to specify an actual date. And it can be relevant in terms of sorting out the finances. If you need to specify a date for pension purposes, you need to try and agree on that. And there can sometimes be disagreements and letters back and forth between lawyers about, what is the correct date of separation. And so it's always best, I suppose, to try and agree on that at some stage, whether it's, the first solicitor's letter, sets that out, that, the decision's been made that they're separated, or, they agree between the parties, this is the date when actually we sat down and we had that conversation, that's the right date to use. But it's not straightforward. And, I say in some cases it's easier to pinpoint than others, really. But yeah, hopefully it's something that can be, agreed between the parties is the best way to solve it.
And in the law in England and Wales, does that date of separation have a massive impact on sorting out the finances? Can it swing things one way or the other?
It's not a massive impact because the financial orders and the financial assets, the court will look at them when they come before the court. So at the point when you do the consent order, or if worst case scenario, you go to court and there's a contested hearing, the courts will look at the assets at that point. So really, the key is to get the finances resolved and get them finalized and approved. But it can be relevant, say, in terms of when you're looking at pensions, for example. Often people want to pinpoint exactly when the date of separation was so that they can try to, isolate, ring fence, post-separation payments into their pension, for example, and any post-separation debts that one party might incur. The other party will be keen to make sure that there's a line drawn in the sand to say, well, that's your responsibility if you've, been, building up debts post-separation. So it is important, but still the court, looks at the assets when you come to divorce as well, really.
Okay. So I guess if you've got one party who's who following separation has taken out a huge amount of debt and gone mad with spending, you want to make sure if you're the other person that the date that you use for separation is before that, so that that's not included. And I suppose the other person might be inclined to use a later date. Are there things that you can do to evidence the date that you believe that you separated? I don't know. I'm just thinking off the top of my head here.
Yeah. Well, yeah. Yeah, I mean, I suppose it, it would be, to send an email to say, this is, we are now separated, get something in writing from the solicitors, and try and agree a date as early as possible, I suppose. So that you're not then arguing about it retrospectively, because it's much harder to then recall, what date you had that specific conversation, or, what date something in particular happened. If you've got something there straight away, whether it's a text message, an email, a letter, just something that you can pinpoint as evidence. And then if there is a dispute and it becomes crucial, it might be that a court has to decide what's the correct date to rely on. So if you've got something that you can pinpoint as evidence, then obviously that puts that person in a better position.
Yeah, no, that makes a lot of sense. I guess it's slightly less important since we had no fault divorce come in, because you used to have that 2-year separation and 5-year separation, which I guess made those dates even more important, whereas now we're not necessarily dating, oh well, yeah, it was definitely 2 years ago from that date, you're not kind of having to decide that, are you?
Yeah, exactly. So I mean, that's simplified the divorce process massively, the new divorce system. Yeah.
Are you finding that people are finding that it's easier to file and to go through that process than previously when we had the it wasn't fault divorce, but I would think no fault, the opposite should be fault. It wasn't quite like that, was it? But under the previous system, is it sort of easier? I know the finances are always going to be complicated, but
the divorce process itself, absolutely, it's a lot more streamlined, a lot more straightforward. And previously, you had to set out grounds and you had to go into some detail as well, which didn't help people, in terms of starting off on the right foot, if one of them's having to blame the other. So yeah, the process is great. And it's so much quicker as well, in terms of using the online systems. It's a lot easier for people, I think. So yeah, it's a very positive change.
Good, because we want to make it not easier for people to split up, because that's the wrong way of putting it. But once you've made that decision to divorce, I think there's no reason to prolong the agony and to make people fight between the two of them any more than is absolutely necessary. And I'm with you that no fault divorces seems to have made a big difference to that. We are nearing the end of our time together, Sarah. Have I asked you everything that I should have asked you about separation and separation agreement?
I think so. Yeah, can't think of anything else.
Good. That's a good start. Do you have any hints and tips that you want to leave our listeners and viewers with?
I think, as you said, it's better to just have everything in writing. Not everything, but, be clear about where everybody stands. When you're moving in with someone, have a cohabitation agreement that sets out who's going to pay what. Are they going to get an interest in the property, or they're not going to get an interest in the property? What will you do when you separate? And then when you come to separate, try to be clear with each other about the way forward in that regard.
Wonderful.
Which I know it's easier said than done from a lawyer. It's easier to say, isn't it? Have a cohabitation agreement. They're difficult conversations to have when you're in a relationship, but it's important to try to have.
They are difficult conversations to have, but if you're in a place where you're happy to move in with somebody, I think those are absolutely conversations that you want to be having, because you don't want to get 25 years down the line and realize that the person you moved in with isn't even comfortable with you having any share in the property, and you believed you were going to get half of it. So I think, however difficult the conversations are, very much worth having.
Yeah, definitely.
Oh, thank you so much for joining me today, Sarah. That was absolutely brilliant. And thank you for joining us. Thank you for listening. Thank you for watching. And we will see you again soon.
Thank you.